Hello, everybody. My name is Christina Mata. For my presentation, I will be going over guardianship. It is the beginning of chapter 11 in our textbook. So, the definition of guardianship is a legal mechanism in where the state delegates authority over an individual's person or state to another party. That party, in most cases, is a family member. But other examples can be a social worker, government agencies, or even lawyers. So, looking at the different forms of guardianship, the first one is general or plenary, where the guardian has total control of the ward's person, estate, or even both. Guardians have the authority to make all and any decisions about the ward and/or their finances. Where we take a look at limited or specific, where this does restrict the guardian's power to a particular type of decision. And guardians may only have the authority to make specific or non-routine courses of treatment. Specific would be a certain medical treatment proposed, and non-routine would be consenting to a major surgery in an emergency. So, in the late 1980s, in order to make guardianship processes more rigorous and fair to potential wards, courts were required to start considering alternatives to general guardianship, and they would have to have provide the same outcome and the same protection for the ward. It also restricted the use of emergency guardianship and did require that at the bare minimum, a full hearing be done as soon as possible. It also encouraged that the presence of the ward in question would be at these guardianship hearings to understand what was going on, as well as assuring that the evaluations of a capacity that were being done were focusing on assessing the functioning capabilities of the ward in question. Now, looking at the basis of guardianship, um, an individual would have to be found incompetent and in need of a guardian to make decisions for them. They could also be presumed to require a guardian, but regardless of their mental capacity, they are incompetent to the law. Now, commitment in an institution per se does not automatically render a person to be incompetent to perform such functions. And because of this, in virtually every state, a committed individual is entitled or has a right to a separate hearing in order to adjudicate the issue of them being appointed a guardian. Now, in determining the need for guardianship, most proceedings occur only when an allegation of incompetent is made. Now, any interested person can petition to have someone declared incompetent and subjected to guardianship. Now, this can become detrimental in some cases because the petitioner may not be acting with the person's best interest in mind. Um, and also, most guardianships are not actively monitored by the court system. And so, individuals don't receive restoration hearings. That can also be troubling given the frequent failure to file guardians reports and there being a lack of inventory for the ward's assets. So transitioning into this next slide, I wanted to mention a documentary I watched titled The Guardians. It documents over a 3-year period span and investigates the allegations of corruption within the Nevada guardianship and family court system, focusing on senior citizens in Las Vegas. So the senior citizens, after they were appointed a private guardian by the court, they were then deceived and drained of their life savings and also lost control over their healthcare and financial decisions. And in this documentary, there were other examples of abuse going on within the system, which showcased individuals who had corruptive motives to control the lives and the states of society's most vulnerable people. So I will be posting a link to the trailer of the documentary so you can see what it would be about. And I'll also post a link to the entire documentary if it's something that you're interested in. You're more than welcome to take a look into it. We're dealing with clinical evaluations in guardianship proceedings. We need to remember that there is a loss of decisional autonomy, and that can have considerable psychological consequences for the ward, where it can impact their mental well-being, their personal control, ability to cope with changes in stress, as well as their physical health. We also should focus the assessment on their ranges of functions that the respondent can perform rather than their diagnosis or symptoms. We should also try to pinpoint and describe the tasks that the allegedly incompetent person can and cannot do. We must also attend to whether weaknesses in that individual's performance are or might be alleviated with the assistance from others, as well as staying attuned to the newest strategies for performing guardianship evaluations. Now, one technique a clinician might use is the direct assessment of functional status. This is used to help determine what a proposed ward can do and handle. It does require the individual to perform independent activities of daily living, or IADLs, with the evaluator assigning points in these each areas. So some examples of these IADLs are cooking, cleaning, shopping, handling finances, and carrying out medical instructions. The original form did contain 85 items, but it was revised in 2010 where it was shortened to 55 items. A second technique would be the assessment of capacity for everyday decision making, or ACE. Now, this one aims at helping an evaluator assess an impaired person's capacity to make a decision regarding being able to solve their own functional problems. Now, this uses a semi-structured interview to help the examiner collect information about their functional deficits. Now, it does allow them to tailor the content to that specific individual, and there is a standardized content for this technique, where the examiner provides the individual with information about a functional problem, gives them options to address it, risk and benefits provided, and then asks the exam individuals at the end to make a decision. This also has the ability to help those individuals with short-term memory loss. Now, there are two models that can guide decision making after a guardian is appointed. A guardian can act according to an objective test, which they can ask themselves what action will most effectively serve the ward's best interest, or the guardian could undertake to make a subjective substituted judgment, where they can ask themselves, what would the ward have wanted or thought to be done if they were competent in that moment. Now, taking a look at the 1989 Croissant versus Missouri Department of Health case, the parents of a 26-year-old woman who was left in a permanent vegetative state after a car accident were looking to terminate the procedures that were sustaining her life. Now, the trial court did approve this termination, finding that their daughter was an independent person who had preferred to do things herself. And it was because of a conversation that she had with a friend prior to her death, where she had expressed that she would not wish to continue living if she couldn't be at least halfway normal. Now, the Supreme Court did find that this evidence was insufficient for determining the daughter's wishes, and they did conclude that the state could require for her life to continue to be preserved with these measures. An advice directive is an instruction from a competent individual that authorizes particular actions if that individual is unable to make the decisions about themselves at a particular time. It is intended to protect that individual's autonomy by ensuring that the person who loses that decision-making capability can receive the care that they would have wanted, by being able to delegate that decision to a surrogate decision maker. Now, some subtypes of advance directives are a living will, durable power of attorney, and the psychiatric advance directive. And advance directives have been around since 1976 and were hastened by the adoption of the Federal Patient Self-Determination Act of 1990. So the Patient Self-Determination Act requires that all healthcare providers who receive Medicare and Medicaid funding provide their patients with information that's regarding their right to participate in treatment decisions and prepare an advance directive. It also gives them the ability to accept or refuse treatment, as well as appointing a surrogate to be their appointed decision maker. And now for our discussion question. Do you think it was founded for Nancy Beth Croissant's life-sustaining procedures to be continued, despite the wishes she communicated to appear the year before her accident? If so, could there have been any other information in addition to her past statement that would make you think otherwise? Finally, here are my sources for my presentation. Thank you all for watching and have a great rest of the day.